Keto and crime, keto and crime. We uncover the grime on keto and crime. Keto and crime, keto and crime. Now is the time for keto and crime.
Hey everyone, welcome to Keto and Crime. Today I've got my summary of days 7 and 8 of the Kyle Rittenhouse trial. So Tuesday of this week and yesterday, which was Wednesday, November 10th. I will have, day 9 tomorrow. But the days were pretty jam-packed. Basically on Tuesday, part of Wednesday, actually just Tuesday, the prosecution finished up its case, finished up its presentation of evidence with, of course, as we know from previously with 𝐜𝐚𝐬𝐸, the paramedic that was one of the last people shot by Rittenhouse, and of course the final questioning there led him to admit that he was only fired upon when he pulled his own weapon. After that, we have a lot of forensic evidence presented. Basically, there was a forensic pathologist that Dr. Douglas Kelly that testified that Rosenbaum, the first person shot, was shot both in the front and the head, which was a minor wound actually, but then was killed by a fatal bullet to the back that was obviously when Rittenhouse fired more than once. When he spun after being hit in the head, he was hit in the back. So it was just mainly forensic evidence. And so basically testified that it was a 4-shot thing, 2 in the front, 2 in the back, with the 4th one in the back being the deadly one. Seemed pretty cut and dry on the prosecution side until the defense asked just a very brief couple of questions, basically asking if the injuries that he saw were as a result of particular body positioning or things like that. And Dr. Kelly did testify that the 2 wounds to the front, the head, the groin, and the 2 in the back were consistent with someone either falling forward or lunging at someone. And then, of course, the defense attorney summed it up by saying, is it consistent that the hand of Rosenbaum was over Mr. Rittenhouse's gun when his hand was shot? The defense attorney asked, and of course Kelly responded, that makes sense. No further questions. So basically just showing that the shots that Rosenbaum received were consistent with somebody having their hand on the weapon. Then basically that was pretty much it. During this time, they debated the whole validity of the 7th charge, which just seemed to me just kind of be tacked on there as being out after curfew, after 8 p.m. And then that was officially dismissed because no evidence had been presented throughout the entire prosecution's case about him being out after 8 p.m. And because the prosecution did not present any evidence to that fact, those charges were officially dropped. A lot of people are probably going to scream, well, it's, no, it's just because they didn't bother to present any evidence. They sort of forgot about that charge, it seems. So can't really blame the judge for that. So basically, one of the defense's first witnesses prior to Rittenhouse was Nicolas Smith, who was also present with Rittenhouse and Dominick Black that afternoon. He said he met Rittenhouse through Dominick Black, and he testified. He's age 23, and he had previously worked as a salesperson at one of the car sources. He testified that indeed the 2 owners, at least one of them, Sam 𝐜𝐚𝐬𝐿, did ask both him, Rittenhouse, and Black to guard their car lots, contrary to what the brothers when they testified on behalf of the prosecution, said this is the second person, Dominick Black being the first, that said they were asked verbally by one of the brothers to guard car source. This is not unusual. Community protection is a thing in the United States. If the police were not offering any protection, which obviously they weren't, because one of the lots burned to the ground, it's well within their right to contract essentially private security. And there are emergency laws that would allow it to be not necessarily a security company. I have a lot of my European subscribers asking about that. And I know, particularly in the UK, where gun laws are so strict, that everything about this case is so weird to you guys. And I totally agree that Rittenhouse would probably be, executed in England. If you even have the death penalty, I don't think you do, but he would receive the top punishment that you have. But the right to protect your body and property is a thing here in the US. We do have the right to carry. Private security is a thing here. So it's not so unusual to us. So I wish I could explain it to my European viewers because I'm not meaning to be condescending by it. I'm just trying to explain that it is a thing here. So it's not so unusual to us. Now, I've said I would not allow my son to be down there. That's my choice. His parents had a different choice. Or maybe they didn't know he was going. Rittenhouse had in fact worked at the pool where he was employed on the 24th, spent the night with his friend Dominick, and then they decided to go down there. So it could be that his parents didn't even know what he was up to, and he may have told them the opposite. We don't know yet, but I'm just throwing that out there. In addition to Smith, they also called Joanne Fielder, another armed woman who had traveled to Kenosha. So there was a lot of people coming in and out of Kenosha, both to protect, to riot, to protest. There were people there and to do criminal activity. There were people there from all over doing their thing. Let's just say that. And the police should have had better control of the area. I will say that forthwith. But basically, she had traveled there, and she was also another freelance journalist, Nathen de Bruyne, who also took photos of everything. Fielder actually said that while she observed Rittenhouse, he was pale, shaking, stammering his words after shooting the men. He was pulling his hair, pulling at his clothes. He was crying. He said, my God, my life might be over. And we were just like, okay, calm down. You need to turn yourself in. So these were probably the people that first saw him after the shooting at Car Source 3, possibly after he had run toward the police and the other two shootings occurred. So Rittenhouse was definitely showing that he was upset that he did not go in there with the intention of killing anybody. He had the gun for protection. And then both of the witnesses, both de Bruyne and Fielder, testified that he only fired after he was threatened. Both Rosenbaum leaping for the gun, as well as 𝐜𝐚𝐬𝐿 having already fired and threatened him with the gun, and then later on, after being hit with the skateboard, and then with 𝐼𝐚𝐬𝐿 actually pulling the pistol on him. And then we move on to Rittenhouse on the stand himself. He had a very tearful retelling of the shootings and especially the threats from 𝐜𝐚𝐬𝐿 that was going on prior to the shooting of Rosenbaum, and he did break down on the stand. I'll drop a clip of that here.
Early direction?
I wasn't.
Describe what happens.
Once I take that step back, I look over my shoulder, and Mr. Rosenbaum was now running from my right side, and I was cornered from in front of me with Mr. 𝐜𝐚𝐬𝐿, and there were three people right there.
Take a deep breath, Kyle.
That's what That's where I run.
We're going to just take time for our break anyway. You can just relax for a minute, sir. We're going to take a break about 10 minutes, and please don't talk about the case during the break. Read, watch, or listen to any comment.
Now, I've seen a whole lot of people, but, you know, he's human. He's human. I'd probably be breaking down myself. And then there was as the testimony went on, and then he basically reiterated it was all self-defense. And then the state began their cross-examination of Kyle Rittenhouse. And then the state seemed to want to gear in onto the fact that he did not have a driver's license. They asked him 5 times, was he driving without a license? He admitted every single time he did. So maybe they want to go back and prosecute him for that. They seem to be honing in on that for a reason. I'm sure to set him up as somebody that with no regard for the law. They started talking to him about why he was out there with a gun. And he said he just wanted to help. And it was just, they were obviously trying to, you know, as is their job, to paint him as someone that had no regard for the law and went out there to do just what he did. And then there came an argument between the defense attorney and the prosecutor, Dingler, about him setting up Anthony Huber as this peaceful person that was just trying to stop an active shooter. And the defense basically went ham, saying that, well, if you can bring out the fact that my client had some, you know, I can bring out Anthony Huber's past, and showed him to be someone that had already threatened his brother with a knife, had threatened to kill and gut his brother like a pig at night. And he said, if you're setting him up as this hero, I'm going to show him the people, the real Anthony Huber. And he was allowed to present evidence of Anthony Huber's prior misfeasance, which is threatening his brother with a knife, the fact that he had been involved in some domestic disputes with prior girlfriends. So the judge allowed it. And then the judge went kind of rogue on the prosecution about the way the prosecution was presenting evidence, saying that you're bringing in things that really shouldn't be part of this case. You're opening up the door to all this extra stuff coming in because of the way you're presenting your case, basically, and basically told him not to chastise him. This judge is an old school judge and only wants to hear pertinent evidence. So he was letting the prosecution know that they were the ones allowing all this superfluous stuff in. And so here's that exchange.
His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. You have.
And then basically after that, it was basically the story that we've heard, basic reaccounting with laser pointers and everything of the video. I'm sure Rittenhouse will be testifying more today, and I'm sure the defense will bring up more witnesses as to what happened that night, eyewitnesses that saw it their way, and we may get a verdict next week. I think we probably will. But that is a real quick summary of days 7 and 8. I hope you enjoyed it. And until next time, Keto Krime.